Archiving started.
I apologize. I've been having all kinds of technical difficulties tonight. I had to end our fifth session. This is our sixth session a little bit prematurely, so I'm going to continue where I left off from our fifth session. We're still on Chapter 4. We're talking about the sources of American law, and we were talking about statutes when we were last together, so I'm going to go to that section and continue the discussion about statutes. And what I was going to do at this point in time, I was talking about federal statutes, and I was going to clear this slide and talk about our three branches of government. I'm sure you will recall this from civics class when you were in high school or perhaps in college. And we had the legislative branch, which we think of as the Congress and our system, our federal system at least. And then we have the executive branch, which we think of as being headed by our president, or if we're talking about state government, we talk about our governor. And then we have the judicial branch, which is our court system. And each one of these branches has a special role that is described in the Constitution, both with a state constitution or a federal constitution. Each one has certain powers, certain things it can do, but certain checks on the powers of the other entities. For example, the legislature gets to pass laws, and it also can impeach the executive, be it the president or the governor. It also is responsible for appointing or approving the appointment of judges. Again, this is more true in the federal system than the state system. And if a judge misbehaves, it can impeach that judge. So those are ways that the legislative branch is a check on the executive and the judicial branch. A way that the executive is the executive's primary function is enforcing the laws that exist, but the executive is also a check on the legislative branch because he can veto laws, and if the legislature can't overcome that veto, then that whatever they want to do in terms of legislation doesn't go into effect. And the executive is a check on the power of the judiciary, because, especially in the federal system, he appoints members of the judiciary. So if he doesn't like someone, he's not going to appoint them. The judiciary's primary function is interpreting the law of the land, the law that's passed by Congress and that's signed by the executive, and also to make sure the executive is following the law when it enforces the law. So the judicial branch is a check on the legislature because it can find laws are unconstitutional, or it can find that what the executive branch is doing, the way that it's applying the laws, is violating what the Congress has said the law ought to be. So the bottom line is that everybody's looking over the other guy's shoulder, and that's the kind of the brilliance, the genius of our constitutional system. The Founding Fathers were worried about anyone having too much power, and so they made sure that somebody else was looking over that entity's shoulder to make sure that if the executive branch became too powerful, then the legislative branch would be able to control it, or if the judicial branch became more powerful, then anyways, if any of these branches became too powerful, there was a check on the power of that governmental entity. So that's what we have here with the three branches of government. And as we said before, the more broad interpretation of the Commerce Clause resulted in federal power, the power of Congress to grow substantially, and the federal government was able to regulate a lot of areas of the economy. Some people think it's a good thing, some people think it's a bad thing, but whatever your views are, it's certainly something that has happened and that has affected what our ideas of the role of government is. And so it's certainly an evolving topic we see with political groups such as the Tea Party. They seem to have an interest in restricting the role of the federal government, having a narrower view of the Commerce Clause. But then, of course, there are other parts of the political community who have a different view, and they would want to even expand the power of the federal government more broadly than it currently exists. I'm not going to do this today because well, we may do this in class if we have time, but we might listen to I'm Just a Bill. For those of you all old enough, when I was growing up at least, there was a show called Schoolhouse Rock, and they showed a little kind of a commercial between cartoons on Saturday morning. And one of those commercials was called I'm Just a Bill, and it showed a bill, a statute. It wasn't a statute yet, but a bill that was hoping to become a statute, and it anthropomorphized him, so he's talking, and actually he's singing, and he's saying, I'm just a bill. Anyway, I can't sing, so I won't inflict that upon you, but it's a very good introduction to how a federal bill becomes law, and honestly, the system is very, very similar on the state level. I don't expect you to know the ins and outs of this, but I just want you to get a sense of the fact that it's a complicated process, and that the vast majority of bills don't become laws. It's an uphill battle for that bill. Poor little Bill sitting on Capitol Hill, he's probably not going to make it. So how does it start? Well, it's introduced to the House of Representatives or to the Senate, one or the other branch. It'll be referred to a committee and possibly a subcommittee of that committee. If it gets voted out of committee, which is a big if, it'll be debated on the House floor if it's a committee of the House that votes it out, or the Senate floor if it's a committee of the Senate that votes it out. And if it gets debated, then it may get voted on by either the full House or the full Senate. If both the House and the Senate pass a law, it will have been amended as it has gone through that process. And so even if identical bills were begun in both houses of our legislative branch, it's unlikely that they're identical at the conclusion of this process. And so then it will need to go to a conference committee to resolve any of these differences between the two versions. And let's say that the committee is able to work out at some kind of compromise that is a little bit like the House version and a little bit like the Senate version. Well, then it has to go back to both the House and the Senate for a final vote. It has to be approved by both. But it's still not a law because the president has a choice. He can veto it or he can sign it. If the president vetoes it, then you need a supermajority to make that law. But even if the president signs it, it doesn't guarantee that it's going to become the law of the land, at least on a permanent basis, because the courts might find that that law violates the U.S. Constitution. If that were to be the case, then the portions of the law that violate the Constitution will not be given the force of law. So it's a very complex process. And, of course, it's designed to make sure that before a bill is passed, there's a lot of thought and reflection, and the democratic process is being utilized fully to make sure that the best laws are passed. A similar process exists in state legislatures. Obviously, a state statute, once it's passed, can't violate the federal Constitution, can't violate federal law, and can't violate the state Constitution. Now, sometimes the Constitution allows the federal government and the state government to both legislate in a given area. So the federal government can act and the state government can act. When this arises, the federal government has the ability to preempt state law. It can say, you know what, we're passing a law in this area, so states, just get out of this business. We're taking this over. And if they have the power at the federal government because the Supremacy Clause gets to act, it can say no state action. It has that ability, but many times it doesn't say that. Many times what it'll say is, we're going to act, but states, if you want to act as well, you can. I'll give you an example from my practice area, employment law. It's very common to have federal statutes relating to employment law issues, but in the vast majority of these statutes, the federal government says it's okay for state governments to give employees more rights. The federal law presents kind of a ground floor. You can't go below that. But if a state wants to give additional rights, that's okay. What is prohibited is a state can't establish a lower standard than what federal law provides. A state doesn't have to give more benefits, but it can if it wishes to. An example of that more broadly is that the federal government currently in 2013 does not outlaw employment discrimination based upon sexual orientation, but many states prohibit that type of discrimination. Not the state of Texas, but we'll say the state of New York, the state of Wisconsin, the state of California. Many states prohibit sexual orientation discrimination with respect to employment. So in those states, you can't discriminate against the categories that are protected under federal law, such as race discrimination, color discrimination, age, gender, religion, disability. And also you'd look to state law and say we can't discriminate against sexual orientation either. But in states that don't have that sexual orientation protection, that doesn't exist. So there are times where there's preemption, but again, there's times where there's not preemption. The way that a state law becomes law is very similar to the federal process. I said that we had federal laws and we also have state laws. So we have a third category. They're usually not even called laws. They're called ordinances. And ordinances are local laws. They're what the county does or the city does. So these are, we'll call it local laws. And local laws or ordinances. And an ordinance is a order, rule, or law passed by a city or county government. An example would be a zoning rule. For example, I can't open up a gas station in the middle of my neighborhood because a city ordinance, a city zoning rule, prohibits me from doing that. Similarly, if I want to build a shopping center in Frisco or Plano or Allen or McKinney or whatever, I'm going to have to meet the local standards for shopping centers. So I'm probably going to need to have a sprinkler system inside, and I'm probably going to need to have a certain number of parking spaces, and I'm going to need to have a certain standard in terms of the physical appearance of the outside of this. Perhaps there's going to need to be some kind of stone facade or something along those lines that meet certain aesthetic standards. And those are going to vary. For example, if instead of us talking about a suburban area like Plano or Frisco, if we were out in a small Texas town that perhaps doesn't have as robust of an economy, the local community isn't going to have a lot of requirements for building the shopping centers. Because if they do, guess what? The shopping center won't be built. And the people in that town might not have a place to buy groceries or to get involved in economic life, and so therefore there might be less employment, or it might be more difficult to buy the essentials of life. So local ordinances are designed to meet the particular needs of that community. And of course, they can't conflict with federal law, the federal constitution, state law, or the state constitution. Another category of law, it's really not separate from federal, state, or local, but it's a category of laws that can apply in any of these contexts, although usually it's going to be applying in the state law context. And they're called uniform or model codes. I'm going to clear this up so we don't have as much writing on here. These are drafted by one of these entities. You don't need to know the names of the entities, but they're designed to establish the best practices. Imagine, for example, that you took classes with 10 different instructors over the course of your college career, and there would be some that had a really great solution to keeping track of attendance. And they had a really great solution to establishing or organizing Blackboard. And you had another instructor who seemed to be able to point you to the right portions of the textbook very easily. And it might be that each one of your instructors had a strength in one place but a weakness at another point. And you might think to yourself, wouldn't it be great if I could take the strength of instructor A and the strength of instructor B and the strength of instructor C and create this super instructor, right? That would be awesome. That's not likely to happen because everybody has strengths and weaknesses, but you can see the appeal of that. Well, that's the idea behind uniform laws. We would have a bunch of legal scholars. Most of them are going to be privately employed. They don't actually work for the government, although they may work for a public university, but they're functioning as private citizens. And maybe they're specializing in, we'll say, family law. And so what they do is they go out and they find out, well, how does Nebraska resolve family law issues? How is it done in Florida? How is it done in Massachusetts? How is it done in Alaska and Wyoming and Nevada and all the states? And they wouldn't just look at the United States. They would look at Canadian provinces. They'd look at Great Britain. They'd look at Japan. They'd look at African countries. They look anywhere to see what are the best solutions to these problems. And many times they would be looking at how technology was informing these choices. And so they would come up with what they thought were the best answers. And then they would propose that to state legislatures. They'd say, hey, we've got this great idea. We think this is going to solve some problems in your state. Now, the state legislature is under no requirement to listen to what these legal scholars say. Sometimes they don't listen to them at all, but they also might say, hey, those are some good ideas. We're going to incorporate them. But until the state legislature incorporates a universal or a model code, it does not become the law in that state. And when the state legislature does decide to adopt a uniform code, it may well make some changes. It may take the model code proposed by that expert and say, well, we like parts A and B and C, but we're not so thrilled with D, so we're going to change D and make it our own. We're going to establish a new type of D, which we'll call D with a bar across the top of it. And so that would be the way that a model or uniform law would be developed. And of course, there can be that customization aspect. The most successful model code is the UCC. The UCC stands for the Uniform Commercial Code. And it is in effect in 49 of the 50 states. The one jurisdiction in the United States that doesn't use it is Louisiana. And you probably already know why they don't use it, because I said before how the Louisiana Purchase, before the Louisiana Purchase, put the word code up here, the Louisiana was owned by the French, and Napoleon was the leader of France at that time, and so he had established this civil code, this very detailed version of the law, and so that civil code was implemented in Louisiana, and so therefore Louisiana has more of a civil law tradition than a common law tradition. It isn't completely without a common law tradition, but it's more of a civil law tradition, and the UCC is based upon that common law tradition. So it just didn't make sense for the state of Louisiana to adopt it. But the other 49 states did adopt it largely in the original format. And let me pause and talk about Texas a little bit. We talk about Texas being a common law jurisdiction. It absolutely is. But it, along with 8 other states, has aspects of the civil law in its tradition. For example, Texas has, let me clear this out here for a second, has community property. The notion of community property is a common law concept. We find that the notion of community property exists in Spanish law and Mexican law. Under the common law tradition, you had something different called equitable distribution. And you don't need to know the ins and outs of this. If you have an interest in this topic, of course, we have a course called Family Law, which is called LGLA 1355. And it is a required course in the paralegal program, so it's very likely that you'll take it. It's also a very interesting course, and it is one that there's a lot of opportunities to practice because, unfortunately, there's marital discord, everywhere, or many folks experience that throughout their lives, and so it is an area that is commonly litigated. So even though we in Texas consider ourselves a a common law state, we also have some aspects of that civil tradition, and so we'll talk about the true false later on. So we, like the other 8 states that have community property, have somewhat of a civil law tradition as well as a community property distribution. So we've talked about 3 of the 4 sources of primary law now. Making good strides here, primary sources. We've talked about the common law or case law. I'm just going to put case law this time. We've talked about constitutional law. I'm going to do an abbreviation here. We've talked about statutes. And we have one more topic that we're going to focus on. This is not a completely exhaustive list of primary sources of law, but this gives you the highlights. And we are going to now talk about regulations, the 4th topic. So we can cross off 1, 2, and 3, and we're going into the home stretch with regulations, our 4th topic. We'll talk about these issues in class, so let's move on to slide number 37. So what is administrative law? Well, it's the law that gives administrative agencies the level of authority that they have. It's about the rules, the orders, and decisions of administrative agencies. The agencies can be agencies of the federal government. For example, the Environmental Protection Agency is a federal agency. It can be agencies of the state government. For example, the Railroad Commission or TxDOT, the Texas Department of Transportation. That would be a state agency. Or local governments can even have agencies. And they are established to perform one or more specific functions. So, for example, if the Environmental Protection Agency decides suddenly that it's going to start a war with Mexico, well, guess what? They don't have the authority to do that. That would be something that the Department of Defense might do. Or the Environmental Protection Agency wouldn't have the authority, for example, to raise the minimum wage or to regulate how overtime pay is established. That would be something the Department of Labor, Wage and Hour Administration would do. Federal state agencies take precedence over state regulations. So a federal regulation trumps a state regulation. How does an agency get created? And this is the way for the federal level, but it's also the way for the state level. Congress, or the equivalent state agency, has to pass enabling legislation. Without the enabling legislation, there is no creation of the agency. So that's kind of how it's born, how it begins its life. Administrative agencies typically have three functions. They make rules. Imagine for a second that you work for the environmental well, we'll say OSHA. Well, you work for OSHA. You are a scientist whose job is to figure out what standards are necessary to ensure that workers are going to be safe and what the procedures are that should exist to ensure that's going to happen. You're an expert in this area. The Congress who passed the law that made sure or that required that employers provide a safe work environment, they didn't know what a safe level of benzene is or a safe level of any particular chemical is. For most part, congressmen and women are usually attorneys, and even if they aren't attorneys, the odds of them being a scientist are not very great. So they don't really know necessarily the ins and outs of the science. That's why they rely upon the administrative agency. So in your role as administrator for that particular agency, you would research it and come up with some rules that you think are good ideas. And once you propose a particular rule, your agency proposes a particular rule, there's going to be a process that you have to follow. You're going to have to make a public notice of the rule. There's going to be a period of time where the public can comment upon it before a final rule issues, which may be the same as the proposed rule, or it may be changed to reflect some of the comments that we receive from the general public. That's one function of the administrative agency. This is very similar to the legislative function, isn't it? Then they also have the function of investigating and enforcing the law. They're going to review documents, they're going to go on on-site visits, they're going to interview folks, and they may proceed with an action against a person or a business in the role kind of a prosecutor. Gee whiz, it sounds a lot like executive role, what the governor's office does, what the president's office does. And then we have adjudication. You can see here, see the word judge in here, or judicial. This is very much like what the judicial branch does. An agency might actually have judges, people called administrative law judges, which are commonly referred to as ALJs. You find in administrative agencies there is no jury. Nobody gets called for jury duty in front of the EEOC or something like this. But if it doesn't get settled, if a complaint is filed and enforcement action is taken, and the entity that's the focus of the enforcement action doesn't agree to some kind of settlement, it's going to have a trial-like hearing before an administrative law judge who's an employee of that agency, and that judge is going to issue a decision with respect to that. He's going to look at the rules that are in effect. There's going to be witnesses and documents that are presented, and he will make a final ruling with respect to that. Now we'll go over to slide number 41 in class. This concludes the discussion of the four primary sources of law. Now we're going to go forward and talk about national and international law. In the first slide that or in the first presentation that we had on Chapter 4, I said that there would be some surprises when we got to national and international law. And this is the surprise I'm going to talk about relates to how we think of international law. This is a common source of confusion, not just amongst non-legal professionals, but also within the legal profession itself. Let's first of all contrast the concept of national law with the concept of international law. Well, national law, no surprise here, is the law of a particular nation. So the national law of the United States is the law of the United States, right? In common law countries, the role of precedent, judicial decisions, is very important. And you find common law countries are usually the United Kingdom or Great Britain and the countries that were formerly part of Great Britain. You also have code countries that are civil law countries, and you find that in continental Europe, and you find that in Latin America and other countries that were once part of continental European empires. You also find that in most of Asia and Africa, especially the parts that were not formerly British colonies. And so in this situation, precedent is not nearly as important, and there's much more emphasis upon statutes. National law is enforceable by that particular government. So if you're talking about a Canadian national law, guess who enforces it? The Canadian government. And usually those laws are only applicable within that country. So if we're here in Frisco, Texas, we're not really focused very much on Canadian law or Nigerian law or Chinese law. That way, if we're going to do business in those countries, we're interested in it. But if we're minding our own business in Frisco, Texas, or Plano, Texas, we're not focused upon the national law of any country other than the United States. This is what most people mean when they talk about international law. Let me give an example. Let me clear the slide here for a second. Imagine that I am here in Texas and I am an international legal professional. Maybe I'm a paralegal, maybe I'm an attorney, I work for a law firm, and we get a call from a company or an attorney who practices in Mexico City, Mexico. And he has a client who wants to open up a base of operations, we'll say in Austin. Let's say we practice in Austin. And they want to hire our law firm to assist the client, the Mexican corporation, in starting its business in Texas. Well, for the most part, the Mexican corporation is just going to have to follow the rules that other Texas corporations have to follow. But that Mexican corporation is very familiar with how it does business in Mexico, but doesn't necessarily know the ins and outs of doing business in Texas. And we're going to help that corporation figure out those answers. But really, we're not going to have to worry about international law at all. We're going to be focusing upon the national law of the United States and also upon the state, the Texas law. And there may be a few issues that we need to know about Mexican law to make sure that the Mexican corporation doesn't run afoul of laws within its own country. But that is all about national law. Let's think about another example. Let's say that we're still in Austin here, and we are representing an American corporation. And that American corporation wants to establish a site in Mexico City. So it's a U.S., a Texas corporation that wants to do business in Mexico. So it comes in and says, hey, help us. We don't know. We know how to do business in Texas, but we don't know what the ins and outs are in Mexico. How do we own property? Do we need to incorporate in Mexico? Do we need to have a Mexican partnership with some entity? What are the ins and outs of that? And so in that role, we would be educating that business about Mexican law, Mexican national law, and also possibly about some aspects of Texas law or U.S. law. But we would not be talking about international law. So most of the business that quote-unquote international lawyers do is really going to be about the national laws of countries other than our own country. Let's talk, though, about what true international law is. True international law is a law that governs relations among nations. So this is when the U.S. has a dispute with, say, Russia, or France has a dispute with Syria. Those are examples of international law, one country against another country. The documents that you refer to are things like treaties between countries or conventions or conferences between countries. Also, organizations such as NATO or the European Community, things along those lines. Also, customs, for example, the law of the sea, things along those lines. Standards that are developed over hundreds of years that most countries find advantageous to follow. Most of these rules of international law are enforceable primarily through courtesy and expedience. It makes sense for the United States to follow international law because it wants to be the beneficiary of international law when it's to the advantage of the United States. Now, of course, if you had a situation of an outlaw country that isn't so concerned about courtesy and expedience, they might violate laws like crazy. If you think back to the behavior of the Nazi government in Germany during World War II, they certainly violated the Geneva Convention greatly with respect to how they treated prisoners of war. So they weren't concerned about courtesy and expedience, whereas the United States, I don't want to say they had a perfect record, but they were more concerned about making sure that prisoners of war were treated with humane conditions because, again, they wanted to make sure that their citizens who were captured in war were hopefully treated in a similar way. And we'll talk more about treaties along those lines. But you can see how there's really not a lot of business to be had with respect to international law. True international lawyers, for the most part, are going to work for a particular nation, whatever that nation is. They might work for the organizations like NATO or the United Nations or the International Court in The Hague or things like that. But working for a private law firm, there really isn't money to be made by practicing true international law. What you're really going to be practicing is the national law of different countries. And we'll go through these while we're in class. So we're going to close up with our summary. We've talked about the four primary sources of law: case law, which is also called common law, state and federal constitution, statutory law, both on a federal, state, and local level. Of course, if it's a local level, it's an ordinance. And we've talked about regulations, both state and federal regulations. We talked about the role of case law in our common law system. We talked about the importance of precedents, the idea of stare decisis, both binding precedents and persuasive precedents. We also talked about the idea of a case of first impression. I'll let me pause and talk about one thing we didn't talk about, and that is the idea of a case on point. A case on point is a case that is very similar to the facts of your case. The legal issue is similar and the facts are similar. Sometimes people talk about a case on all fours. And this would be a case that has similar parties, similar facts. Let me do up here, similar facts, and similar legal conclusions, holdings that the court is making, and also a similar procedural posture, similar way that the case developed in the court system. And there you have a case on all fours. Procedural history is what I'll call it now. We'll talk more about this in subsequent lectures, but I wanted to cover this briefly here. Case law governs all areas that are not specifically covered by a statute. Then we talked about how constitutions are the supreme law in their domain, but the courts, of course, are responsible for interpreting and construing the constitutional provisions. Then we talked about how statutes are implemented both on the federal level and the state level, and again, how they're construed by the courts. We talked about the role of administrative agencies, that they really have the three branches of government all rolled into one. They have the legislative function, the executive function here, and they have the judicial function here. And then we talked about laws of other nations and international law and how that works in our system. If you have any questions, be sure to bring them to class. At this point, we have concluded Chapter 4. Thanks for your attention. Bye-bye.